very warm greetings to one and all present here. It's been after a long that we are meeting on this platform for one more interesting lecture. I, Dr. Shikha Dhaman, Assistant Professor, Department of Laws, Guru Nanak Dev University, Amritsar, will be enlightening you all on the topic Internal Aids to Interpretation of Statutes. Let's start with an introduction. Statutory interpretation is the process by which courts determine the meaning of legislation. It is a fundamental aspect of judicial function aimed at realizing the legislative intent. The interpretation of statutes involves various methods including the literal rule, golden rule and the mischief rule, each with its own approach to understanding the legislative text. Internal aids play a very pivotal role in these interpretive processes, offering insights directly from the statute. An aid is a device that helps or assists. For the purpose of construction or interpretation, the court has to take recourse to various internal as well as external aids. Internal aids means those materials which are available in the statute itself, though they may not be the part of the enactment. The interpretation of statutes is a fundamental aspect of legal practice as it involves deciphering the meaning and the intent behind the legislative text. Internal aids to interpretation are intrinsic elements within a statute that assist in understanding its provisions. These aids are crucial for the judges and legal practitioners to ascertain the legislature's intent and also how to apply the law accurately. Further, we have various internal aids of interpretation, their significance and how these aids are utilized in the legal contexts. Internal aids to interpretation means those materials which are available in the statute itself, though they may not be the part of the enactment. These internal aids include long title, preamble, headings, marginal notes, illustrations, punctuation, proviso, schedule, transitory provisions and many more. When the internal aids are not adequate, court has to take recourse to external aids. External aids may be parliamentary material, historical backgrounds, reports of a committee or any commission, any official statement, dictionary meanings or any foreign decisions. Now let's discuss the meaning and significance of internal aids to interpretation. It refers to the components within the statute itself that provides guidance on its meanings. These aids are essential for resolving the ambiguities and ensuring that the statute is applied as intended by the legislative bodies. They play a pivotal role in understanding the legislative intent, which is the cornerstone of statutory interpretation. By examining these internal elements, courts can derive a more precise understanding of the law, thereby promoting consistency and fairness in its application. The importance of internal aids in legal interpretation cannot be overstated. They provide a structured approach to understanding the statutes, minimizing the ambiguities and enhancing the precision of legal outcomes. By relying on internal aids, courts can uphold the integrity of legislative intent and contribute to a coherent and predictable legal system. Now let's discuss about various and different types of internal aids. First is the title of the statute. The title of the statute provides a brief indication of its subject matter and purpose. It can be useful tool for interpretation, especially when the language of the statute is ambiguous. The title can offer insights into the legislative intent and the scope of the statute. Now, under the title, we have one long title. The long title of a statute is an integral part of the statute and is admissible as an aid to its construction. Statute is headed by a long title and it gives the description about the object of an act. It begins with the words "an act to," that's it. For example, the long title of the Criminal Procedure Code 1973 is "an act to consolidate and amend the law relating to criminal procedure." In recent times, the long title has been used by the courts to interpret the certain provisions of the statutes. However, its usefulness only to the extent of removing the ambiguity and confusions and is not a conclusive aid to interpret the provisions of the statute. In a very landmark bill, that is of the Reference Kerala Education Bill, the Supreme Court held that the policy and purpose may be deduced from the long title and the preamble. In the case of Manohar Lal versus State of Punjab, long title of the Act is relied as a guide to decide the scope of the Act. Although the title is a part of the Act, it is in itself not an enacting provision, and though useful in a case of ambiguity of the enacting provisions, it is ineffective to control their clear meaning. Another type of title is short title. The short title of an act is for the purpose of reference and for its identification. It ends with the year of passing of the act. For example, the Indian Penal Code 1860, the Indian Evidence Act 1872. The short title is generally given at the beginning with the words, "This act may be called so and so." For example, Section 1 of the Indian Evidence Act 1872 says, "This act may be called the Indian Evidence Act 1872. Even though short title is the part of the statute, it does not have any role in the interpretation of the provisions of an act. Another aid is preamble. The preamble of a statute outlines its objectives and the reasons for its enactment. It serves as a guiding tool for interpretation, helping to clarify the purpose and intent behind the legislation. The preamble can be particularly useful in cases where the statutory language is unclear or open to multiple interpretations. The main objective and purpose of the Act are found in the preamble of the statute. It is a preparatory statement. It contains the recitals showing the reason for enactment of the Act. If the language of the Act is clear, the preamble must be ignored. The preamble is an intrinsic aid in the interpretation of an ambiguous Act. If any doubts arise from the terms employed by the legislature, it has always been held a safe means of collecting the intention to call in aid the ground and the cause of making the statute and to have the recourse to the preamble. In the case of Kashi Prasad versus State, the court held that even though the preamble cannot be used to defeat the enacting clauses of a statute, it can be treated as a key for the interpretation of the statutes. But however, this preamble has some limitations as an internal aid to construction. The first limitation is, preamble can be resorted to only when the language of a provision is reasonably capable of alternative constructions. Number 2, the preamble cannot either restrict or extend the meaning and scope of the words used in the enacting part. Number 3, in case of conflict between preamble and a section, the preamble would succumb and the section will prevail. Number 4, a preamble cannot be regarded as a source of substantive power or any prohibition or limitation. Another internal aid is the marginal notes. Marginal notes are brief annotations placed in the margins of the statutes that summarizes the content of specific sections. While not legally binding, they can provide valuable context and aid in understanding the statute's provisions. Marginal notes are the notes which are inserted at the side of the sections in an act and express the effect of sections stated. Marginal notes appended to the articles of the Constitution have been held to constitute the part of the Constitution as passed by the Constituent Assembly, and therefore they have been made use of in construing the articles. In the foreign case of Wilkes versus Goodwin, the court held that the side notes are not the part of the act and hence marginal notes cannot be referred to. Now we have some of the limitations of these marginal notes. The first limitation: marginal notes are very rarely used for interpretation as they are not considered to be the good aid to construction. Number 2, only those marginal notes can be used for construing a provision which have been inserted with assent of the legislature. Number 3, marginal notes can be called in aid only when the language suffers from ambiguity and more than one construction is possible. And number 4 is marginal notes cannot frustrate the effect of a clear provision. Next aid is headings. Headings are used to organize the statute into sections and subsections. They help in structuring the statute and can assist in interpreting the provisions by indicating the general theme or the subject matter of a particular section. Headings are of two kinds. One is prefixed to a section and other is prefixed to a group or set of sections. Heading is to be regarded as giving the key to the interpretation, and the heading may be treated as preambles to the provisions following them. But at the same time, we do have some limitations for the headings also. Firstly, headings can neither cut down nor extend the plain meaning and scope of the words used in the enactment part. Number 2, headings cannot control the clear and plain meaning of the words of the enactment. In the landmark case of Krishnaiya versus State of AP, that is of 2005, it was held by the court that headings prefixed to sections cannot control the plain words of the provisions. Only in the case of ambiguity or doubt, heading or subheading may be referred to as an aid in construing the provision. In another case of Durga Thatera versus Nareen, the court held that the headings are like a preamble which helps as a key to the mind of the legislature but do not control the substantive section of the enactment. Now let us come to the another internal aid, that is the definition clause. The definition clause provides specific meanings for terms used within the statute. This clause is crucial for ensuring that the terms are interpreted consistently and in accordance with the legislature's intent. The object of a definition is to avoid the necessity of frequent repetitions in describing the subject matter to which the word or expression defined is intended to apply. A definition contained in the definition clause of any particular statute should be used for the purpose of that act only. Definition from any other statute cannot be borrowed or used ignoring the definition contained in the statute itself. Another internal aid is illustrations. Illustrations are examples provided within the statute to clarify the application of its provisions. They serve as practical guides for understanding how the statute should be applied in a specific situations. Illustrations in enactment provided by the legislature are valuable aids in the understanding the real scope. In the case of Mahesh Chandra Sharma versus Rajkumari Sharma of 1996, the Supreme Court held that illustrations are the part of the section and helps to elucidate the principles of the sections. Now we have another internal aid, that is explanations. Explanations are additional clarifications provided within the statute to elucidate certain provisions. They help in resolving the ambiguities and ensuring that the statute is interpreted as intended. An explanation is added to a section to elaborate upon and explain the meaning of the words appearing in the section. An explanation to a statutory provision has to be read with the main provision to which it is added as an explanation. An explanation appended to a section or a subsection becomes an integral part of it and has no independent existence apart from it. The purpose of an explanation is not to limit the scope of the main section. An explanation is quite different in its nature from a proviso. The latter excludes, accepts and restricts, while the former explains, clarifies or subtracts and even includes something by introducing a legal fiction. Another aid is schedules. Schedules are appendices attached to the statute containing detailed information or supplementary provisions. They are integral to the statute and must be read in conjunction with the main text of a comprehensive understanding. Schedules form a part of a statute. They are at the end and contain minute details for working out the provisions of the express enactment. The expression in the schedule cannot override the provisions of the express enactment. Another aid is punctuation. Punctuation marks, though often overlooked, can significantly impact the interpretation of a statute. They help in structuring the sentences and clarifying the meaning of the text. Punctuation is a minor element in the construction of a statute. Only when a statute is carefully punctuated and there is no doubt about its meaning can weight be given to the punctuation. It cannot, however, be regarded as a controlling element for determining the meaning of a statute. But at the same time, we do have some limitations of the punctuation. Some jurists have opined that punctuation marks are of no use as internal aids to construction, and it is an error to rely on punctuation marks in construing the acts of legislature. Presence of a comma or absence of comma must be disregarded if it is contrary to the plain intention of the statute. Now we have another internal aid, that is saving clause. A saving clause is a provision within a statute that preserves certain rights or privileges despite changes in the law. It ensures that existing rights are not inadvertently nullified by the new legislation. Another aid, that is proviso. A proviso is a clause that introduces a condition or exception to a general rule within the statute. It is used to limit or qualify the application of certain provisions. The normal function of a proviso is to accept and deal with a case which would otherwise fall within the general language of the main enactment, and its effect is confined to that case only. There may be cases in which the language of the statute may be so clear that a proviso may be construed as a substantive clause. But whether a proviso is construed as the restricting the main provision or as a substantive clause, it cannot be divorced from the provision to which it stands as a proviso. It must be construed harmoniously with the main enactment. In the case of CIT versus Ajax Products Limited in the year 1964. Now we have the limitations of the proviso. Firstly, proviso is constructed in relation to the section to which it is appended. Another limitation is the ambit and scope of enacting sections cannot be widened or curtailed by the proviso. Now we have another internal aid to interpretation, that is exception. An exception is a provision that excludes certain cases from the general application of the statute. It is used to carve out specific situations where the statute does not apply. Exceptions are generally added to an enactment with the purpose of exempting something which would otherwise fall within the ambit of the main provision. An exception may be referred to for the purpose of constructing the enacting portion. Construed strictly and strongly against the party trying to take the benefit. If an exception is repugnant to the operative to be the part of the section, it must be ignored totally. If an exception is given an enactment, is supposed that the provisions of the enactment will apply to all the other cases which are not covered by the exception. In the case of Farmers Bank of Fayetteville versus Hale, it was held in this case that an exception in a statute which is inconsistent or repugnant with the main body of the act is totally void. Saving clauses are generally inserted when a statute is repealed or reenacted. A saving clause exempts a particular thing from the general things enumerated. A saving clause which is repugnant to the body of act is again void. Now let us discuss some landmark cases regarding the internal aids in a statutory interpretation. For instance, in the case of Hayden's case of 1584, the court emphasized that the importance of understanding the mischief rule that the statute intended to remedify. The preamble and other internal aids were instrumental in determining the legislative intent. Similarly, in R versus Judge of the City of London Court of the year 1892, the court relied on the literal rule of interpretation, highlighting the significance of internal aids such as definitions and explanations in understanding the statute's provisions. In the case of B. Prabhakar Rao and others versus State of AP and others of the year 1986, Justice Chinnappa Reddy has observed, where internal aids are not forthcoming, we can always have recourse to external aids to discover the object of legislation. External aids are not ruled out. This is now a well settled principle of modern statutory construction. In the case of District Mining Officer and others versus Tata Iron and Steel Company and another of the year 2001, the Supreme Court further observed that it is also a cardinal principle of construction that external aids are brought in by widening the concept of context as including not only other enacting provisions of the same statute, but its preamble, existing state of law, other statutes in pari materia, and the mischief rule which the statute was intended to remedify. In another case of K.P. Varghese versus Income Tax Officer Ernakulam, 1981. Once again, the Supreme Court has stated that the interpretation of statute being an exercise in the ascertainment of meaning, everything which is logically relevant should be admissible. In another case of State of West Bengal versus Anwar Ali, in this case, the constitutionality of Section 5 of the West Bengal Special Courts Act 1950 was challenged on the ground that it is violative of Article 14 of the Constitution, as the provisions in the Act authorize the state government to select a particular case which deserved to be tried by special courts having special procedure. The Supreme Court then took the help of the preamble of the said Act and held that the state government has the discretion to choose such cases. In the case of Tolle versus Giddings, the interpretation of Section 217 of the Road Traffic Act was in question, which provided that a person could be held liable of an offence if he allowed himself to be driven away in a motor vehicle without the consent of his master. The heading of the provision is miscellaneous and general, and the subheading is penalization of taking motor vehicles without authority. Accordingly, the court held that the heading to the section clearly explains the intention of the legislature, and thus the passenger would be held liable for an offence. Now, these were all the internal aids, and now we are coming to the conclusion. Internal aids to interpretation are indispensable tools for legal practitioners and judges in deciphering the meaning and intent of statutes. They provide valuable insights into the legislative intent and ensure that the law is applied consistently and fairly. By examining these internal elements, courts can resolve ambiguities and promote a more accurate understanding of the law. In conclusion, internal aids play a vital role in legal interpretation, contributing to the effective administration of justice. Relying solely on internal aids can lead to challenges, particularly when the statutory language is ambiguous or incomplete. Internal aids may not always provide a comprehensive understanding of the legislative intent, leading to potential misinterpretations. Also, internal aids, while valuable, are not immune to ambiguity and misinterpretations. Elements such as punctuation and provisos can be open to different interpretations, leading to inconsistency in the application of law. Thank you everyone for your valuable time and attention. I also appreciate the opportunity to speak and share my views with you today. Thanks once again. Take care. God bless you all.